Imagine this. A lawyer, someone you trust with property deals, suddenly facing criminal charges. And not just any charges using fake documents.
Right.
It sounds like a thriller, but this actually happened. It went all the way to the highest court, and the whole thing hinged on, well, what does fake even mean when we're talking about a legal document?
Welcome to the deep dive. Today we're jumping into a really complex legal case. We've got property deals in Hong Kong, this unique housing policy, and yeah, the really fascinating nitty-gritty details of forgery law.
Yeah, one of you shared this legal judgment with us and asked us to kind of unpack it. What does it really tell us about, truth, deception, and how the justice system handles it?
So our mission today is to dissect this case, figure out the core conflict, and pull out the key takeaways without getting totally lost in legal jargon. We'll look at the accusations, the different ways the law was interpreted, and the pretty surprising result.
Okay, let's set the scene first. This whole thing revolves around something called Hong Kong's small house policy. What exactly is that, and why is it so central here?
Okay, the small house policy. It's quite specific to Hong Kong's new territories. Basically, it was set up to help indigenous male villagers, they're called ding, build their own houses on favorable terms.
Indigenous male villagers, okay.
Yeah, eligibility is strict. It's tied to lineage. You have to be a male descendant of someone who was a resident in a recognized village back in 1898.
Wow, 1898.
Yeah, and there are a few ways it works, grants, special leases, that sort of thing. But the absolute key point for this case is a condition. Once the house is built, you can't sell or transfer it for 5 years.
Right, 5-year restriction. Got it. So meant for ding housing. How does the specific property deal in this case fit in?
So things really kicked off between 1996 and, into the 2000s. Initially, this plot of land, some of it farmland, was bought by two guys, let's call them Mr. Su and Mr. Lau. They paid HKD $380,000.
Okay.
But here's the interest rate. On the exact same day, they transferred it to a Mr. Chan, who was a ding, eligible for the policy, and the stated price for that transfer, only HKD $200,000. Mr. Chan became the registered owner on paper.
Same day. Much lower price.
Yeah.
To someone eligible for the policy.
Right.
Yeah, that sounds like something's going on behind the scenes.
It certainly suggests that. And yeah, the evidence points pretty strongly to Mr. Chan just being a nominee, a name on the deed.
Right.
Soon after, Mr. Chan, represented by a solicitor's firm, applied for the building permit under the small house policy. That got a provisional green light in 97.
Okay.
Then, in early 98, Mr. Chan gives power of attorney to Mr. Su, one of the original buyers, allowing Su to deal with the lands department.
So Sue is now acting for Chan.
Exactly. It really looks like Su and Lau were the beneficial owners, the ones actually pulling the strings and standing to benefit.
Okay, so Chan's the owner on paper. Sue and Lau are likely the real owners. And the building permit comes through.
Yep, granted in April 98. And crucially, the permit paperwork specifically noted that 5-year restriction on transfer after completion, standard procedure for the policy.
Okay, we got the land, the permit, the 5-year clock starting eventually, and this nominee arrangement. Now enter the appellant, the lawyer, Mr. Zhang San, and two others, Mr. Shen and Ms. Lai.
Right, this is the next phase, roughly 2000 to 2007. In October 2000, Mr. Su, remember, he's acting for Mr. Chan with that power of attorney, appears to transfer the beneficial interest in the property. Not the legal title, just the underlying interest.
Okay, to whom?
To Ms. Lai Kikom. The price stated this time was HKD $1,050,000. Now, Mrs. Lai was described as the de facto wife of a Mr. Shen Jiangrong. It was Mr. Shen who actually put up the money, and he considered himself the real beneficial owner at this point.
So another layer. Sue transfers the interest to Lai, funded by Shen, but Chan is still a registered owner.
Still Chan on the title deeds, yes.
Right.
And Mr. Zhang San, the solicitor we're focusing on, he represented Shen and Lai in this. He even witnessed the agreement between Su, acting for Chen, and Lai. But significantly, this agreement wasn't registered with the land registry. So Su and Lau seem to be out of the picture now. Chan is still the registered owner, which had to be the case, right, to keep the small house policy status.
Right, otherwise the whole thing falls apart.
Exactly. So Shen and Lai then actually build a house on the land. Mr. Zhang San's firm, still technically acting for Chan, notified the lands department when it was finished. The certificate of compliance gets issued in 2002.
And Shen and Lai move in.
They move in, and it's worth noting, no prosecutions happened regarding any of the statements made to the lands department during this whole building phase.
Interesting. So no legal issues there. They're living in the house. Chan's still legal owner on paper. and that 5-year restriction is still ticking away.
Eh.
What happens when it finally expires? This feels like where the trouble really starts.
You got it. The 5-year period ended in March 2007. Things moved quickly after that. In May 2007, Mr. Chan grants a new power of attorney, this time directly to Mr. Shen.
Okay, so Shen can now act for Chan.
Yes. And this document, drafted and witnessed by Mr. Zhang San.
Ah, Zhang San is still involved.
Very much so. Now, with this power, Shen and Lai decide they want to get a mortgage on the property. They instruct Mr. Zhang San to handle it all, including, finally, transferring the registered ownership from Chan to Lai.
Okay, so the end game is to get Lai's name on the title deed officially. How did Zhang San go about this?
Well, his firm prepared a formal sale and purchase agreement. It named Chan, acting through Shen, using the power of attorney, as the seller, and Lai as the buyer.
And the price.
The stated price was HKD 3 million. The agreement also said HKD 1.5 million of that had already been paid.
Okay, 3 million total, 1.5 million supposedly paid up front.
Right. A copy of this agreement was faxed over to a finance company, Universal Finance, in May 2007. This was to help secure the mortgage for the other HKD 1.5 million.
Makes sense.
The agreement itself was formally signed in June 2007. Lai had actually applied for the mortgage back in May, and it got approved pretty quickly.
Okay, mortgage approved, based partly on this sale agreement. What else happened document-wise?
So in June 2007, Zhang San's firm submits the documents supporting Lai's loan application to Universal Finance. And crucially, that includes a copy of that sale and purchase agreement.
Right.
That's the basis for count 1 against Zhang San using a copy of an allegedly false document.
Okay, count 1.
Then, Universal Finance tells Zhang San to prepare the mortgage documents, the legal charge on the property. The sale and purchase agreement itself gets registered at the land registry, also in June, and Mr. Zhang San personally signs the accompanying memorial form, basically verifying the contents of the agreement for the registry.
I mean,
That's count 2, using an allegedly false document, the agreement itself, to induce the land registry.
Got it. One more.
One more, Zhang San's firm prepares the actual transfer deed. This formally transfers ownership from Chan, via Shen, to Lai. It also states the consideration as HKD 3 million. This is signed in June 2007. Universal Finance then releases the mortgage money, just under 1.5 million, to Zhang San's firm. Most of that, about 1.44 million, gets transferred on to Mr. Shen.
Right.
Then that transfer deed is registered in July 2007. And again, Zhang San signs the memorial form verifying its contents for the land registry.
And that must be count 3.
Count 3, exactly. Using another allegedly false document, the transfer deed, to induce the land registry.
So 3 charges. Using a copy of the agreement with the finance company and using the agreement itself and the transfer deed with the land registry. The core accusation being these documents were false.
Precisely. The prosecution argued Universal Finance was induced to grant the mortgage, and the land registry was induced to register these documents, all based on documents that were allegedly false. The detriment was the loan being given out and the official records being updated based on, well, potentially false information.
So how did the first court, the district court, see it?
The district court judge, Judge Lau Ke-yi, found Zhang San guilty on all counts. She bought the prosecution's argument. She said the sale agreement and the transfer deed were false because they contained lies.
Lies about the money.
Exactly. The HKD 3 million price, the statement that 1.5 million had already been paid. Zhang San had actually admitted in separate earlier proceedings, money laundering proceedings against Shen and Lai, interestingly, that those figures weren't accurate representations of the actual flow of funds.
Okay, so he'd admitted the figures were off.
Yes, and the judge ruled this meant the documents fell under a specific part of the Crimes Ordinance definition of a false document, Section 69A, basically saying they looked like they were made under certain circumstances, a genuine sale at that price, but actually weren't.
So the district court focused on the untrue statements inside the documents, making the documents themselves false. What about the Court of Appeal? Did they agree?
They agreed with the guilty verdict, yes, but their reasoning was a bit different. They also found the documents were false, but focused more on the underlying transaction. They said the whole setup, going back to the small house policy stuff, was essentially a sham.
Sham.
Yeah, they argued a real sale agreement implies genuine negotiation between a real buyer and seller. They felt that wasn't the case here between Lai and Chan, or Shen acting for Chan. It wasn't a genuine market transaction in their view, especially given the policy context. So the documents representing it were therefore false.
So, still guilty. But the justification shifted slightly, less about the specific price lie, more about the whole deal not being what it purported to be. Which brings us to the Court of Final Appeal. This false document definition seems absolutely critical.
It was the entire case, really. The CFA granted leave to appeal specifically on this point. What does false document mean under that Section 69A7 of the Crimes Ordinance? They basically laid out two possible interpretations.
Okay, what were they?
First, there's the broad interpretation. This was the one the lower courts used. It says a document is false if it contains lies about outside facts or circumstances, like the details of the sale transaction itself.
Right, like the price.
Exactly. But then there's the second view, often called the lie about itself approach. This argues that forgery laws are traditionally aimed at documents that lie about their own making.
Their own making? How so?
Like, who actually made the document? Did they have the authority to make it? Was it made when and where it claims to have been made? Was it altered later without authority? It's about the document's authenticity in terms of its creation, not just whether the statements in it are true.
That's a subtle but potentially huge difference. Did the CFA look at where this law came from?
They did a deep dive, yeah. They went back to the UK Law Commission report from 1973 that led to the UK's Forgery Act 1981, which Hong Kong's law mirrors. And that report was pretty clear. It said forgery targets documents that look genuine but aren't. The deception lies in the document's provenance, its creation, not just untrue statements within it.
So the original intent wasn't to catch every written lie.
Seems not. They quoted this old English case, R.V. Windsor from 1865. Forgery is the making of a false document in order that it may be used as genuine. A false document means a document false in itself. The Law Commission explicitly said they didn't want to expand forgery to cover just any written falsehood about external facts.
Okay, so the legislative history points towards that lie about itself idea. But you mentioned the lower courts used the broader view. What about previous court decisions? Was there a clear precedent?
Well, that's where it got tricky. The CFA reviewed a whole bunch of cases, and frankly, they were kind of all over the place. There was a UK case, R.V. Donnelly, that supported the broad view finding a valuation for non-existent jewelry was a false document because the supposed inspection never happened.
Okay, so that supports the lower courts here.
Sort of, but then another UK case, Attorney General's reference, no one of 2000, tried to narrow Donnelly down. And a Hong Kong case, Secretary for Justice v. Young Hong Kong Larry, had also used that broad interpretation for some fake employer letters.
So some support for the broad view.
Yes. Other big cases went the other way. The UK House of Lords in R.V. Moore rejected the broad view. They said a withdrawal slip signed by the actual account holder wasn't false, even if used fraudulently, because the document itself was genuinely made by who it said it was.
Right, it didn't lie about its own making.
Exactly. And another UK case, Warnford and Gibbs, heavily criticized Donnelly and stressed the law was about the circumstances of the making of the document, not external facts. And closer to home, a Hong Kong case, HKSR v. Hun Bat Moy, also rejected the broad view. That involved a passport with real details, but a fake photo. The court said it wasn't false under the ordinance because it didn't lie about who issued it or the core biographical data.
Wow, okay. So definitely conflicting lines of thought in the case law. What did Hong Kong's highest court, the CFA, finally decide was a correct interpretation?
They came down firmly on the side of the lie about itself approach. They said you have to read Section 69.8.7 in context with the rest of the forgery laws in the Crimes Ordinance and all those other sections. They focus on the genuineness of the document itself, its making, its alteration.
So the broad view taken in that Young Hong Kong Larry case was wrong.
They explicitly said it was incorrect, yes. The CFA clearly preferred the logic from cases like R.V. Moore, Warnford and Gibbs, and Hun Bat Moy. A document isn't false for forgery purposes just because it contains lies about something else. It has to lie about itself.
Okay, that's a major clarification of the law. So applying that specific standard, the lie about itself standard, back to Mr. Zhang San's case, what did that mean for him?
It meant the original basis for his conviction was flawed. The prosecution's whole case and the district court's finding of guilt rested on the idea that the untrue statements about the price and payment made the documents false.
Which is the broad interpretation the CFA just rejected.
Right. And the Court of Appeals reasoning, focusing on the underlying transaction being a sham, also wasn't about the documents lying about their own making. So the CFA looked at the sale agreement and the transfer deed. Did they contain lies about the deal? Yes, apparently. But was there any evidence they lied about who made them, or when, or with what authority? No.
They were signed by the people they said they were signed by, using the power of attorney, witnessed, dated correctly.
As far as the evidence showed, yes, they were technically authentic in their creation, even if they contained factual inaccuracies about the deal itself. So under the correct lie about itself interpretation of Section 69(7), they weren't false documents for the purpose of the forgery charges.
And the result?
Mr. Zhang San's convictions under Sections 73 and 74, the ones about using false instruments, were overturned, quashed.
Wow. Acquitted on all charges then? Or did the prosecution have a plan B?
They did try. The prosecution asked the CFA, okay, if not forgery, can we substitute convictions for something else, like conspiracy to defraud or maybe fraud under the theft ordinance?
Can the appeal court just swap charges like that?
There are rules for it, yeah, under the Criminal Procedure Ordinance and the District Court Ordinance. But there are strict conditions. Basically, the original indictment must have contained allegations that could have supported the alternative charge, and the appeal court has to be satisfied the facts proven at trial would establish guilt for that other offense.
Okay, so could they substitute here? Conspiracy to defraud.
The CFA said no. To prove conspiracy to defraud, you need to show an agreement between people to act dishonestly to defraud someone. The original forgery charges, they didn't allege any specific agreement like that, so the first condition wasn't met.
Okay. What about the other option, fraud, under the theft ordinance?
Same problem, essentially. That fraud offense requires proving a dishonest deception that leads to a specific prohibited result, like someone obtaining property, getting a financial advantage, or causing someone else a loss. The original forgery indictment just didn't contain allegations about those specific outcomes. It was focused purely on the documents being false and being used. So again, the CFA said the conditions for substituting a conviction weren't met.
So no substitution possible based on how the case was initially charged and argued.
Correct. The CFA refused to substitute any convictions.
It really sounds like the prosecution's initial choice of charges focusing specifically on forgery was absolutely crucial to how this all ended.
It really was. And the CFA actually made a point of saying this at the end. They stressed that overturning these forgery convictions shouldn't be seen as them condoning the whole scheme that was set up with the property and the small house policy.
They weren't saying what happened was okay, just that it wasn't forgery as legally defined.
Exactly. The legal mess arose because of the specific charges brought, rather than potentially other charges, like maybe conspiracy or substantive fraud, which might have fit the facts differently, but weren't the charges Zhang San faced trial for.
So wrapping this up, what's the big picture takeaway here? It seems to boil down to this really fine legal line.
It does. The law, at least this specific forgery law, makes a clear distinction between a document that just tells lies about the world and a document that is, itself, a lie about how it came to be.
A document containing lies versus a document that is a lie about its creation.
Precisely. And that difference, which might seem subtle, had massive consequences in this case. It completely changed the outcome for Mr. Zhang San.
It also really drives home how vital it is in law to match the charge precisely to the alleged facts and the specific legal elements of that offense. You can't just say something dodgy happened.
Absolutely. And it shows the complexity for appeal courts when they're reviewing decisions and interpreting these fine points of law.
So this deep dive into the Zhang San case gives us this really fascinating window into legal interpretation. And it reinforces that principle, for this law anyway, that a document has to lie about itself to be a forgery. It really makes you pause and think, doesn't it? How much do we just assume documents are authentic?
We rely on it constantly. And this case shows what happens when that authenticity, or at least the legal definition of falsity, gets challenged in court.
And, for you listening, while the legal outcome was acquittal on these charges based on that definition, the whole underlying story.
Yeah, the way the small house policy seems to have been used, the nominee arrangements, the shifting beneficial ownership, it definitely raises ethical questions about honesty, transparency, and maybe the spirit versus the letter of the law in property dealings.
Definitely food for thought. What part of this case stood out most to you? Does it make you think differently about legal documents or the justice system? We'd genuinely love to hear your thoughts.
Thanks for joining us on this deep dive. Until next time, keep questioning, keep digging, and keep learning.